When I meet with a potential client about divorce, I like to explain the process to them. I start by explaining that there's two kinds of cases. One is an uncontested case and the other is a contested case. In uncontested cases, the parties file joint forms together asking for divorce. One of the forms that they file is called a separation agreement. The separation agreement is a very important document that should be drafted by an attorney or at least reviewed by an attorney because it sets forth both parties' rights and obligations with things like concerning things like child custody and child support if children are at issue, alimony, and the division of assets and debts. In contested cases, the process can be a little bit more difficult. Cases started when a plaintiff files a complaint in the county in which they live. The complaint asks for divorce, sets forth the grounds for the divorce, and any other relief that they're seeking, like the award of property or alimony and things of that nature. Once the complaint is filed, the court clerk issues a summons and assigns a judge to the case. The documents then need to be served on the defendant, who has 20 days to file an answer. If the defendant doesn't file an answer within 20 days, the plaintiff can move forward in the case by default. That means without the defendant's involvement in the case. Assuming that the defendant does file an answer, both parties are required to submit to the other financial statements. There's a short form for people who earn under $75,000 per year, and a long form, which is a lot more detailed, for people who earn over $75,000 per year. There are a bunch of schedules and attachments that may be needed to be attached to the financial statements, and these are important disclosures that have pretty important significance in a divorce case. It lets the other party and the court know exactly what the assets, debts, income, and expenses are that are involved in the case. The failure to provide accurate disclosures could have negative consequences in the case. Once the financial statements are done, the parties can begin negotiating a settlement. Also, during this middle stage, either party can file a motion with the court and ask for temporary orders concerning anything that needs to be ordered while the case is pending. Typically, things like child custody and child support and alimony are the subject of motions that are filed with the court for these temporary, or what we call pendente lite, orders. Either party is allowed to conduct discovery during the pendency of a case. That means information gathering. In addition, after both parties are ready and feel like they have all of the information sufficient to move forward in the case, they either resolve their case by a settlement or they go to trial. Unfortunately, going to trial is a lot more costly and time intrusive than resolving a case. And in my experience, about 80 to 90% of cases settle before they ever get to trial.